1947, which allows actions against the Crown for certain torts, but again, it is limited in scope, and it would be very difficult to prove the duty of care in such a case as border security. Likewise, negligence claims, you would have to prove a duty, then a breach, then causation and damage. And I've said previously, the biggest difficulty that people have is proving the direct causation of damage. So the damage could be somebody's injured or killed. The duty is proving the initial duty of care, and you cannot just apply a broad duty of care to everybody on a policy or a policy decision. You can't say this is a policy and policy decision, things that they're doing about it, and therefore there's a general duty of care to every single person. That is very difficult. You usually have to establish a direct and positive duty of care. For example, a child attending a school, there's a direct relationship. The school is responsible for every child. So albeit every child, but there is a direct link there. And even if you establish a duty of care, you then have to establish a breach, which may be possible. But then obviously the damage might be easy to prove as well. But then you have to prove the causation. Did it cause the damage, or in the case of injury or death and so on, did it cause that, or was there an intervening factor, such as somebody acting independently in criminal enterprise or terrorism? And again, that could be very difficult to prove. So all of these things make it very difficult to prove, not to mention time-consuming and expensive and so on. Now, there are certain things that we can look at, such as the border security, asylum and immigration